Hi, good afternoon. I'm Bianca Dueñas. I'm a staff attorney with Lone Star Legal Aid from our Longview, Texas office. Today, we're joined by a representative from Texas Advocacy Project, and she'll introduce herself in a minute. Today's topic is sexual assault reporting and specifically civil legal remedies available to the public. This presentation is intended to serve as legal information only. It does not replace legal advice. Now, you are free to contact Lone Star Legal Aid at 1-800-733-8394, or you're welcome to visit our website at lonestarlegal.org for more information on legal assistance. Lone Star Legal Aid does not discriminate on the basis of race, color, religion, gender expression, sexual orientation, age, national origin, ancestry, disability, marital status, or military status in any of its activities or operations. All right, so thank you for being with us. Will you please introduce yourself, Ms. Ellison?
Hi, my name is Allison Kolb. I am a managing attorney at Texas Advocacy Project. A little bit about Texas Advocacy Project. We are a nonprofit law firm serving the entire state of Texas. We are able to help people in any county within the state of Texas. And we have really just two qualifying criteria to be a client of Texas Advocacy Project. One is that you are a survivor of intimate partner abuse, whether that is sexual assault, domestic violence, child abuse, stalking, indecent assault. As long as it's a form of intimate partner abuse or power-based abuse, we are set up to help you, and that you have an issue of Texas state law that you need help with.
Perfect. So we'll go ahead and start. Can you just note for our audience the difference between criminal legal remedies and civil legal remedies, which is what your entity focuses on providing?
Yes, so as a non-state agency, we are a nonprofit. We are not, prosecutors or the district attorney. We offer civil legal services. And there's a big difference between the criminal process and the civil side of things that is not necessarily intuitive if you're not a part of the legal profession and used to that. The criminal process is one where the consequences for the perpetrator are much higher, but the victim, the survivor's agency is a lot lower. Whereas in the civil process, the survivor has a lot more agency in what happens, but the consequences and remedies are maybe a little less satisfying for the survivor, depending on what their wish is. So in the criminal process, that's when someone has committed a crime as defined in the Texas Penal Code, and it's investigated by police and investigators and detectives and passed on to a prosecutor, who then decides whether or not to press charges, indict the defendant, and either make a plea bargain or eventually go to trial and get a conviction. And the result of that could and can be prison time. So incarceration is what happens at the end of a successful criminal prosecution. On the criminal side, the survivor doesn't have a ton of agency. You often hear people talking about, oh, this happened to me, and I want to decide whether or not I'm going to press charges. And the survivor intuitively thinks that that may be completely their decision. And that's what feels fair to us. However, in a criminal case, it's not actually the survivor versus the defendant, the abuser. It's the state of Texas versus the abuser. So it's actually the state that decides whether or not to proceed with the criminal case. And the police decide how much of an investigation happens and how thoroughly they're going to investigate. And police and prosecutors have a whole lot of discretion there. And so if a victim really wants, if a survivor really wants the police to investigate and the prosecutors to push the case forward, the best thing that they can do is be very, very cooperative and make their wishes known in that case. But the decision is ultimately out of their hands. There are many wonderful prosecutors and investigators out there who are very respectful of survivors' wishes. And survivors have had varying experiences in that system, but the ultimate decision is not their own. With the civil side, the survivor has a whole lot more agency because they are almost always the ones deciding whether or not to bring the case in the first place. But a civil case does not end in jail time or prison time. The result of a civil case is a civil remedy, which is often dollars and cents. You're suing somebody for money. Or in my practice, more often, it's a protective order, which is an order that says that someone has to stay away from the survivor. It doesn't put them in prison, but it says that they are not allowed to go near them or their home or their work or school, depending on the terms of the order. Another remedy in a civil case is custody of children or divorce and the disposition of assets through the divorce. But at the end of a civil case, nobody ends up in prison. So the remedies are less extreme and sometimes less satisfying to a survivor, but the survivor does have a lot more agency over whether or not that case moves forward.
Now, you mentioned that typically in criminal cases, the state does not represent the victim. And so the prosecutor is not there, even though they respect the victim's wishes. They're not there to advocate on behalf of the victim directly, as opposed to in a civil legal suit, the attorney is literally and directly representing the victim and their desires and their desired outcome. And that ultimately gets placed before the judge, correct?
Absolutely. So in my practice, because I'm on the civil end, my boss is the survivor because my agency Texas Advocacy Project happens to serve specifically survivors of abuse. So they are my boss and I do what they say and I take the case as far as they want. But a prosecutor's boss is the state of Texas, and the state of Texas has an interest in making sure that crimes get prosecuted. And sometimes they will take a case forward, even if the victim prefers that they don't, and vice versa as well. Whereas on the civil end, we're able to tailor everything to the survivor's wishes.
Okay, so let's start with some of the services that you stated your agency offers, and that is protective orders. Now, there's different types of protective orders that our audience is not always familiar with. A lot of times, the general population, when they hear protective order, they think of the 2-year common family violence protective order, but there's additional types of protective orders. Would you go into detail?
The 2-year family violence protective order is very much the most common and the oldest type of protective order in the state of Texas. But we do have some other protective orders available. A protective order is only ever available after a crime is committed against somebody. Now, it doesn't have to be proved beyond a reasonable doubt like it would be in the criminal system. Another perk, if you would say, of the civil system is that we don't have to prove these things beyond a reasonable doubt. It's a lower burden of proof. But for protective orders, there still has to have been a crime committed before it is available. So family violence is the most common crime for a protective order, but we also have protective orders available for stalking, for sexual assault, for human trafficking, and indecent assault. Sexual assault is basically a shorthand of explaining the legal definition of sexual assault in Texas is what most people would think of when they hear the word rape. Indecent assault is the newest type of protective order. It's actually a new crime that was recently codified in our penal code, and it is a sexually motivated assault or an assault of a sexual nature that doesn't quite rise to the level of sexual assault. We have protective orders for both of those, in addition to trafficking, stalking, and family violence.
And if it's an individual that has fled a different state and has come to Texas, are there any type of emergency protective orders in the civil system that are available to them?
There is some conflict in the law about that, but there are some thoughts out there that if none of the violence occurred in the state of Texas, that there may be jurisdictional issues for the state of Texas granting a protective order against somebody. So for protective orders, a court may or may not feel comfortable granting one of those based on jurisdictional grounds. However, if a client is in need of something different, like a divorce or an order for custody, you can get a divorce in the state of Texas against someone who has never set foot in the state of Texas. If you have fled violence and you come to the state of Texas and the violence was by your husband or wife or spouse, you can still get a divorce because Texas will grant a divorce for a Texan once they happen to have been a Texan living in Texas for 6 months. And you can even get a very short-term emergency custody order for your children if you fled violence in Texas. But there are different bodies of law that govern when a court would have full jurisdiction over a divorce or full jurisdiction over a custody case. Some of them are actually pretty complicated, for lack of a better word, treaties between the states where they decide how they will respect each other's custody orders and how they will determine which state has custody. Has jurisdiction over a custody order, but if someone is fleeing violence and they need a very short-term order to get them custody of their children in an emergency, there are special there are special provisions that allow for that in emergencies.
Okay, awesome. And you touched a little bit on divorces. In order for somebody to get divorced in Texas, you mentioned they had to be in the state of Texas for at least 6 months. Is that correct?
So for someone to file a divorce in Texas, either the petitioner or the respondent needs to have been in Texas for 6 months. And that's a jurisdictional issue that is listed in our code, in our family code. So if someone flees from out of state, they must establish that residence here by living here for 6 months, unless the adverse party happens to already be in Texas and have been here in Texas. So it's husband, wife, or spouse, one party to the marriage has to have been here 6 months.
Is it the same jurisdictional requirements for somebody that is not married and just has children with their abuser when they come to the state of Texas?
That is a tricky issue that is governed by what we call the UCCJA, Uniform Custody Child Enforcement Jurisdiction Act. I messed up the acronym. It's a tongue twister, but it is an agreement between most of the states. I believe Maine may not be a party to it, but most of the states in the US have an agreement where they will decide how and when a state has jurisdiction over a custody case. And there are a couple things at play. One is does the child live, and where has the child lived for the past 6 months? One is, has another state made an order pursuant for custody before? And if so, if the child moves to another state and is there for a certain amount of time, that new state may eventually obtain jurisdiction, but there are some procedural things that would have to happen. The short version is that it can get very complicated. But like we mentioned before, Texas does have a special provision in our code that if it's an emergency, regardless of another state having jurisdiction of custody at the time, there are some ways under some circumstances that Texas can make at least a short-term order while jurisdiction gets figured out if it's necessary for the safety of the child.
Now, in your experience, specifically in your agency, when individual survivors of sexual abuse seek these legal remedies such as divorce or custody, does the perpetrator tend to be, I'm going to assume, the spouse, or there's been some type of abuse to the children? Is that correct?
I mean, one or the other, both. We see numerous different types of cases. And so we say they're a married couple. I have had cases where the husband or wife or spouse who is my client is the only target of the abuse. I've had cases where the children are the main target of the abuse. I've had really heartbreaking cases where the children were sexually abused by one of the parents. Some of them were seeking to terminate the parents' parental rights, and that is one of the types of cases and civil remedies that we provide for our survivors that is, done within the civil system. So it happens in a lot of different ways, and sometimes surprising ways that you wouldn't predict. So I hope that answers your question.
And when people seek assistance for parental rights termination, since we covered a little bit on the difference between a criminal case and a civil case, is there any requirement that the individual be charged with a sexual crime in order to be able to move forward with the parental termination?
For termination of parental rights, there are a number of different grounds that allow this in our family code. It's actually one of the hardest cases to win on factual grounds, because most family law cases have a lower burden of proof, preponderance of the evidence. But termination of parental rights has a higher burden of proof, clear and convincing evidence, which is the second highest burden of proof, aside from what we use in a criminal case, which is beyond a reasonable doubt. And there's a couple things that you have to prove to terminate parental rights. One is that one of the grounds that our law recognizes that is the basis for terminating the rights is applicable in the situation. The other is that it is also in the best interest of the child. So you have to prove both of these by clear and convincing evidence. Whereas if you were just divorcing or just getting a custody order, you would prove it by a lower burden of proof. It would not take quite as compelling of evidence to do that. The reason that the law makes these cases harder is because Texas does recognize that we all have a very important interest. All of us who happen to be parents in general in the state of Texas, have a high interest and constitutionally protected interest in being the parents of their children. and their parental rights. So the state makes it harder to terminate those rights than many other types of civil remedies. Some of the grounds that are available for terminating parental rights are sexual assault against the other parent. So say I may have a client who is the mother of the child and the father has been convicted of sexually assaulting her. It used to be that that would not necessarily be a ground for termination of parental rights unless that was the way that the child was conceived through a non-consensual act. However, the law was updated that being convicted of sexual assault can itself be enough to meet a ground for termination of parental rights. I was very happy about that update to the law personally. It used to be a little bit harder. Some other grounds that are available are being convicted of a crime against a child, quite a few different crimes against a child that causes serious bodily injury to the child. And that, of course, includes a lot of sexual offenses against the child. This could be the child at issue in the case, the child who the one parent is trying to terminate the other parent's parental rights. It could also be a different child. However, that knowing that this person has been convicted of being, having hurt a child, whether it's aggravated assault or sexual assault, a whole different list of crimes against children that may apply, that opens the door for the parent of the other child, the child at issue in this case, to bring the suit. Regardless of the ground, you still have to prove that best interest standard though, so it's 2 steps. A couple other grounds that are somewhat commonly used for termination, and when I say common, I will say that these are slightly uncommon cases because we have that public policy in the state of Texas of being hesitant to terminate rights. But a couple other commonly used grounds are non-payment of support that for over a year. That does tend to be the weakest ground, and I don't see a lot of judges being willing to grant termination of parental rights just on that. Usually in our cases, we'll use that as an additional supporting ground. But some other grounds that you could use for termination of parental rights would be endangering the child. Let me see if I can think of any other off the top of my head. Murdering one of the parents, the other parent of the child, or attempted murder, that's certainly a ground for termination of parental rights. Endangerment, non-support, abandonment during pregnancy. And those are the ones that we are most likely to use in our practice. Another one that's actually common that is tied in with a conviction is being convicted of a crime that's going to land the respondent in prison for 2 or more years. So regardless of what that crime is, if it results in a conviction and this person is going to be incarcerated for 2 or more years, it opens the door to terminate parental rights. So getting one of those grounds opens the door so that you have a basis to file the suit. The other parent has standing to file the suit in the first place, but they still have to prove to the judge that it is in the best interest of the child to terminate those rights. Termination of parental rights also generally terminates a child support obligation. So there are quite a few judges who are hesitant to do that, because there's a public policy with the idea that maybe this person will reform and be a good influence, and they want to leave the door open to have a good relationship in the future. But B, because the state likes to have people on the hook for child support. So the cases in which we find we have the highest chance of terminating parental rights are cases where there may already be a protective order, a lifetime protective order that the child is on and the child is a protected person. The idea being maybe there's no love lost because the parent who's the respondent is already not allowed to have a relationship with that child. Or where that respondent parent is incarcerated and is going to be incarcerated for a good long time, possibly even through the child reaching the age of majority. In those cases, it's easiest to convince a judge to terminate parental rights. But where we have egregious facts, sometimes we get in front of a judge and they are ready to terminate. It really varies greatly based on the judge and the circumstances.
Now, we've touched a lot on civil legal remedies that are sought by individuals that, for the most part, have some form of dating relationship or romantic relationship with the perpetrator. What about those individuals that have suffered assault, for example, at a college campus get together or some type of social event that took place on campus that they weren't necessarily dating the individual? Do you know what legal services are available through your agency for individuals like that?
Absolutely. There are circumstances where a protective order may still be available despite the fact that there's no relationship. And if it's in an educational institution that receives any federal funding, Title IX also applies. And we do quite a bit of Title IX advocacy at Texas Advocacy Project. So I'll start by talking about protective orders, and then I'll move on to Title IX. So I know we're going to revisit protective orders for a moment. But earlier we mentioned that there are different types of protective orders: family violence, sexual assault, indecent assault, stalking, and trafficking. With a family violence protective order, you do have to show that there's a special relationship, whether it is family in terms of a marriage, in terms of being a close blood relative, or a close in-law or a close step sibling, or oddly enough, dating relationships come under the family violence protective order. We just have some confusing language that we like to use in our laws and our remedies in Texas. So even though family violence protective orders are called family violence protective orders, they're also available to people in dating relationships. But not everybody who is assaulted is in a dating relationship to begin with. There are stranger assaults and there are acquaintance assaults that happen all the time, especially in the college context where people may be acquainted and know each other and be in a situation that is conducive to somebody being a predator towards somebody else, perhaps a party where there is alcohol and bystanders are not, in a place to intervene. By the way, I'm a huge fan of bystander intervention. I think that's one of the best things that all of us can do to prevent sexual assault. But say that there's no dating relationship and no family relationship. If there is a sexual assault or an indecent assault, a sexual assault or indecent assault protective order is still available. You do not need to show any pre-existing relationship to qualify for a protective order if it's under sexual assault or indecent assault, or stalking or trafficking. So those protective orders are still one potential remedy. If the assault took place on campus or at a campus-sponsored event or in a setting where the school has an amount of control and both of the parties are affiliated with the school, whether they are both students, one is a professor and one is a student, one is an employee and is a student, maybe they're both employees of the school in some way, and it's on school ground, or it's at a school-controlled event, or even at an organization that is officially affiliated with the school, even if they're not owned or controlled by the school. And that is, I'm referring really to fraternities and sororities there. If it's on their property, even that's owned by the fraternity or sorority and not the school, then the school has the ability to use Title IX. And in fact, the school has an obligation because Title IX is a federal law and it is tied to federal funding. So this applies only to schools that receive federal funding. But here's the secret, that's almost every school. Almost every single school, even private schools, even religious private schools, even private schools that may not be very pro-government in their philosophies, most of them do take some federal money. And it only takes a single penny of federal money for Title IX to apply. So any school with federal funding is required to actively prevent gender-based discrimination, which our laws consider gender-based violence, including sexual assault, stalking, and dating violence to be included under that. So they have to actively prevent gender-based discrimination, including assaults, and they have to actively address and remedy incidents when gender-based discrimination, including assaults, happen. And by the way, just so to be perfectly clear with Title IX, this is not only meant to protect women. This is meant to protect anybody who's discriminated against or assaulted because of their gender. Whatever your gender is, whatever your identity is, whether you identify as male, female, or neither, as non-binary. Title IX applies to anybody as long as they are affiliated with the school and the school is receiving federal funding. So there's a whole complicated process and a whole complicated set of rules that a school must follow when they become aware of a sexual assault or another form of gender-based violence or discrimination occurring, if it's on their campus, at an event that they have control over, at a fraternity or sorority or equivalent group that is affiliated with the school and on that group's property or what they have control over. And so when this happens, there's normally a fairly formal process for reporting it to the Title IX coordinator or the Title IX office with the school. And there's a fairly formal process where the school investigates. The school can provide accommodations to the survivor. And then depending on the way that the parties in the school want to proceed, there may be a very formal investigation. Sometimes there's a less formal investigation if the survivor asks the school not to proceed and the school doesn't want to. But if the school is going to do a serious investigation, the respondent has a right to a hearing. And the school will actually have a proceeding that feels a lot like a trial, even though it is in essence a school disciplinary proceeding. And that feels very confusing because you see a school acting almost like a judge and jury. But there are a lot of protections put in place and procedural things put in place to make sure that it is actually fair to both parties. This is, by the way, an extremely controversial area of law, and it is always constantly changing. And every time we have a new presidential administration, that administration decides it's going to change the rules for how the Title IX departments need to handle the investigations. But currently, as it stands right now, the schools are required to have a hearing if there's a formal investigation where both the victim and the respondent have the chance to interview witnesses and cross-examine each other's witnesses. And the school may also have witnesses and cross-examine and interview the witnesses. They have advocates who do the interviewing and cross-examining for them to prevent an abuser from directly harassing a survivor in the hearing, and also to make it fair to everyone and give everybody a chance to be heard. And it's oddly enough fairly common for both the survivor and the abuser, or in the world of Title IX, we call them the complainant and the respondent, for them to hire attorneys to serve as their advocates in the Title IX proceedings at the school. So we at Texas Advocacy Project will actually serve as advocates for survivors in what feels like a trial, but is actually a school disciplinary hearing. And so if they are in the college level, secondary education, that hearing is required as long as there is a formal investigation in the first place. And if they are in the K through 12 setting, Title IX does still apply. However, the live hearing is not required, the idea being that perhaps an 8-year-old who's still in elementary school should not be subjected to that process. So there is at least that one kind of forgiving instance for younger survivors there. But that's a long-winded explanation of Title IX. The confusing thing is that it's not technically in either the civil or the criminal courts. It's in the schools, but lawyers get involved because they're helpful and because the law says what the schools have to do to make sure that they're helping survivors. And one of the best things the school can do for a survivor under Title IX is give them accommodations, whether or not there's enough evidence to find that an assault actually occurred. And unfortunately, with sexual assaults, one of the biggest things that plague investigations and cases, whether they're criminal, civil, or Title IX, is lack of evidence. So it's very common that we just don't have the evidence to get the ruling that we want. But in Title IX, we can get accommodations regardless of what the school finds. So we can get a change in class schedule, we can get a no contact order to keep the students apart from each other and keep them, so that they can proceed with their education in peace. We can get housing changes, we can get a survivor's name taken down from the student, registry books, or what I mean to say is the guide where you can look up people's names, and the name is escaping me. But different things to keep them safe and give them peace, and of course connection to counseling and that sort of services. So there's a lot you can do with Title IX that can help you even if you're not seeking a remedy where you get someone in trouble. I do have clients who don't want a big investigation, they just want some help from the school, and Title IX can sometimes do that without triggering a big scary investigation. And it really depends on how you work with the Title IX office and what you ask and how you advocate for yourself, or how the attorney who's helping you advocates for you. One thing that I want to note is, again, we were talking about the difference between the different systems earlier. So with the criminal system, it is all about punishment. It is all about incarceration, the idea being that this is going to be something that's going to prevent future crimes. The civil system is more about making the survivor whole, whether that is that divorce that they need to move on, custody of their kids, termination of parental rights, or a protective order to just keep someone away from them so that they can move on. It's giving them other remedies that help them move on with their life. And Title IX is a combination of the two. But what I always like to ask my clients when I first meet them is, what does justice mean to you? Because accountability is extremely important to some clients. And others don't care about that so much. They want peace and they want the things that they need to move on in peace. And that's their focus. And they don't want to engage necessarily with the criminal system. That can be a bit harrowing. They might not even want to engage with the civil system or Title IX. They just might want to look into what they can do and understand their legal rights and figure out how to plan their lives so that they can just, separate in peace.
Now, while you were speaking, I was reminded of your agency also helps with landlord-tenant issues. Is that correct? Because you mentioned that in Title IX, one of the remedies is you may be able to switch to a different dorm. But for those that are not living in dorms, do you provide assistance with helping them break the lease, and what do they have to prove to be able to do that?
So our bread and butter is largely the protective orders in Title IX and family law, but we try to provide any civil legal service that is going to help someone break free from the abusive situation. And if you cannot feel safe in your home, you can't break free from the abusive situation, but we all have rent to pay, right? We can't pay two rents at the same time, at least most of us can't. So there is a wonderful provision in the property code that says that you can break your lease early without penalty if you have survived a crime, sometimes on the premises, sometimes off. It gets a little bit nuanced, but there are different ways that you can invoke this right. Normally, depending on the circumstances, but normally you have to give your landlord notice that you are invoking this right, and you have to give them 30 days notice and proof that you are a survivor. And that proof can be various different things. A protective order is a great piece of proof. A court order with a finding can sometimes be a piece of proof. Sometimes we are even able to just have an advocate write up that they are helping someone because they're a survivor. Medical records can also sometimes be proof, and it depends on the situation. But it is a formal way, and you have to take certain steps to invoke your right to terminate your lease early. And it doesn't get you out of fees that you already owed. Maybe you're late on previous month's rent, or there are some damages or that sort of dispute, but it does get you out of rent that you would owe in the future. And so that's helpful because maybe you're 2 months into your year-long lease, and you don't want something bad showing up on your credit saying that you terminated for no reason, and you're not going to be able to pay the rent on this one. So you're worried about how long it's going to take for the landlord to refill the apartment, and how many months that landlord is going to try to come after you for. And so this can be, a buffer to combat that. And then another thing that can sometimes be helpful is the Attorney General of the state of Texas's Crime Victims Compensation Program. Sometimes they are actually able to help people cover moving expenses if they need to move into a new home because they were abused in their home and they need to move on, especially if there's been an arrest for an assault against them. And so that's a program that we have helped people understand and apply for. And there's actually, I've helped people appeal a denial of crime victims compensation because I have learned that actually there are quite a few cases that get appealed on the first level that are get denied at first, but are successful after there's an appeal. Now, to be eligible for crime victims compensation, there usually has to be a reported crime and an arrest. And the survivor does need to be cooperating with prosecutors and investigators to be eligible for those funds. And I always recommend that people save their receipts because they do need to prove what they spent. But it is one more remedy that helps make someone whole. And it's not a criminal case. It's not even, a civil case. It's actually administrative. But it's one more kind of tool we have in our tool belt to try to help survivors build up their lives and get some freedom so that they can move on in peace.
Awesome. So I want to close up our time together by touching base on, you mentioned there's other types of services that you connect your clients with that are not necessarily legal remedies. And I know that in our entities, we try really hard to foster and nurture partner agencies that may offer different services than what our agency focuses on. And so in your office, since you cover the entire state of Texas, that is a lot. What type of services or other agencies are you able to connect the individual with? I know briefly you had mentioned some counseling. Are there specific partnerships that you have that are your regular go-tos? Do these change varying on where the individual resides?
It definitely changes varying on where the individual resides. We maintain partnerships with domestic violence shelters and rape crisis centers throughout the state of Texas. And we would not be able to serve the entire state of Texas without this help. Absolutely. They're so important to us and what we do. And so depending on where a survivor is located, if we know of an appropriate agency that is going to be helpful for them, we will absolutely refer them to that agency. One thing that's important to know is that many domestic violence shelters have advocates who do not require you to be living in the shelter to receive their services. Some of them do require that, but many, many do not. And many actually continue to provide services for long after someone leaves the shelter. Many can provide services whether they have ever been staying in the shelter or not. We find that a lot of our clients don't necessarily want to move at all, and they maybe are hesitant to move into a shelter even temporarily for a number of reasons that we absolutely respect, and that's perfectly fine. But that doesn't mean that an advocate at a shelter is not going to be helpful to them. Another thing that we do is we actually have an in-house social work department now that we've had, oh gosh, for I think about a year. And I'm so glad that we have them, because as an attorney, I can help with legal issues, right? I'm good with that. And with housing, I can help someone break their lease. I can help them apply for crime victims compensation. But what I can't do is come up with a new house for them. But our social work department has the expertise and the understanding of all of the aid that is out there with housing, with counseling, with WIC, with things that can help food insecurity, with TANF and all of these different resources that can help meet someone's practical needs. Because let's face it, a huge part of abuse is financial abuse. Abusive personalities, they will very carefully craft a situation where they come in looking like this lovely, wonderful person, and slowly they will build dependence. And one of the ways that they build dependence is through isolation and financial sabotaging. So we have a lot of clients who have all the debt in their name and none of the property in their name. Or perhaps their career or studies have been sabotaged by the abuser. And perhaps the abuser have said, you don't need to keep your apartment, move into mine. Don't bother with the paperwork. And then their name will be on the lease, but not the client's. So we have a lot of clients who are facing food insecurity, facing job insecurity, facing, having no income, facing housing insecurity, worried that they are going to end up on the streets if they leave their abuser. So having a social work department in-house and being able to partner with local agencies really helps us figure out a lot of those practical problems. But let's face it, a lot of people need to face. They need to know where their next meal is coming from and where they're staying tomorrow night and tonight before they can worry about filing a lawsuit. So being able to partner and do kind of a holistic approach really helps someone escape from this carefully crafted trap that their abuser has laid to keep them with them.
And that's good to know. And so if somebody needed to access your services, what would be the best way to contact someone from your agency?
So we have a legal advice hotline. We call it our Hope Legal Line, and that is the first contact that many of our survivors have with our agency. We also have referrals that we take from our partner agencies, of course, but any Texan who is a survivor of abuse and has an issue, a civil issue of Texas state law, can call this hotline and we will get you an appointment with one of our attorneys in the near future to get legal advice. And we can also advise on a criminal matter, but because we are not criminal defense attorneys or prosecutors at this time, we are not representing people in criminal matters. Our HOPE hotline is 800-374-4673. Those last 4 digits spell out HOPE, H-O-P-E. It doesn't matter what your background is. It doesn't matter what your income is, your national origin, your religion or lack thereof, your sexual identity, orientation, your gender, your income, your race, your ethnicity, your national origin, any category that you can think of. We don't care. We are just set up to serve survivors of abuse who have issues of Texas state law that they need advice on, and perhaps legal assistance and perhaps representation. So many of our cases start with a legal advice call and go from there. Many of our clients are able to get what they need just from advice. We have different levels of services that almost always start with that Hope Legal Line.
Okay, awesome. And if they wanted to reach you online, what is your website? And I'll go ahead and type it up for people on the call.
It is I want to say it's texasadvocacyproject.org. Of course, I don't have it right in front of me.
Let me pull that up. And they can apply using that online forum, correct?
There is an online form on the website, yes. And oh, just to be clear, we do have Spanish-speaking attorneys, and the Hope Legal Line goes straight to our intake screeners. And our intake specialists, our screeners, are also the people who handle our online applications, and all of them are 100% bilingual, 100% fluent in Spanish and English.
Perfect. I am going to go ahead and add that to the chat box so that people have access to the website.
Thank you.
Yes, there we go.
I guess if I could just leave a final thought.
Yes.
The cool thing about having different legal systems is that they serve different needs. And like we said before, the criminal system is more about accountability. The civil system and Title IX, civil system is more about making somebody whole. And Title IX can be a bit of both, right? But you don't have to do all of them at the same time. You can, but you do not have to. You can decide what justice means for you and what your goals are and pursue whichever remedies you want based on that. As we mentioned before, in the criminal system, the survivor doesn't necessarily have complete control, but they do have control over whether they report, and they have control over, whether they want to ask prosecutors to proceed with the case. And then you don't have to seek a remedy that you don't want. And if all you want is a divorce, you don't have to prove anything beyond a reasonable doubt to get that. The state of Texas is not in the business of keeping people who don't want to be married. If you want, custody of your child, you don't have to prove everything to the same standard as you would in a criminal case. Some of these cases are much easier to get the remedy than it would be in another. But you as a survivor get to decide what you want to pursue and what is best for you. And then I know at Texas Advocacy Project, because we are set up specifically to serve survivors, we're here to listen to what your goals are and figure out the best legal strategy for you to get to there.
Well, thank you so much for being with us today. We really appreciate all of your insight and describing more thoroughly the legal civil remedies that are available to victims of sexual abuse. That way they have the ability, as you said, to be empowered to make those decisions for themselves on some of the options that they would like to pursue. I have put the Texas Advocacy Project legal hotline on the chat box for anybody that wants to give them a call for further legal specific advice that is specific to your situation. And as previously stated, Lone Star Legal Aid also has their phone number that you may reach them at 1-800-733-8394 or lonestarlegal.org. But we partner with Texas Advocacy Project because they do cover the entire state of Texas. Lone Star Legal Aid only covers 72 counties in the state, which covers basically Galveston all the way up to Paris, Texas. That way you get a visual of the areas that we cover. And so we thank you for the work that you do and for being one of the agencies that partners with us to further provide individuals the civil legal services that they need. For anybody that is viewing on the live stream, if there's any questions that you have at this time, we'll go ahead and take them. And if those do show on the comments, then I'll go ahead and read those live. I'll just give a few seconds for those to be mentioned. And if we do not receive any questions through the live feed, then this video will be available for further viewing, and you can share with anybody that you think needs the information that was discussed today on the options that they may have when it comes to civil legal remedies. And we thank you for your time, and we thank you, Allison, for being with us today.
Thank you.
Okay, I've been told there's no questions at this time. So like I said, we'll leave this video up on our Facebook Live website, and you can go ahead and share with anybody that you feel free needs to have access to this information. We thank you all, and we hope you have a wonderful day. Thank you, Allison.
Thank you.